welcome to today's webinar. We're looking at the UK Data Protection Law Reform under the Data Use and Access Act 2025. Before we start, a couple of things about housekeeping. The first thing is if you have any questions, and we do welcome questions, please put them in the Q&A and not the chat. The chat is not working for you. It's been disabled so that all questions go into the Q&A. Just to let you know that a recording will be sent out after the event, so you will get that, and you'll also get a PDF of the slides. So hopefully that will be useful for you. So the Data Use and Access Act. I think it's fair to say it's the biggest shake-up since GDPR came in. There's quite broad reforms in it, and we're going to have a look at the key parts of the Act today. Just to let you know, I'm Joanne Bone and I'm a partner and lead the data protection practice at Owen Mitchell, and I've also got Josh presenting with me today, who's a specialist data protection lawyer in the team as well. Also, final bit of housekeeping, there is a feedback form, so if you could fill in the feedback form if you've got anything that you'd like us to present on in the future, or have got any comments, that would be great. So, in terms of the Act itself, as you'll see, it's been kicking around for a while. There has been the intention that data protection laws would be reformed for quite a while. There was originally a proposal in the short-lived Liz Truss government, and there have been different versions since then, but this one's actually gone through and was passed, as you can see on the slide, in June this year. I think it's useful to have some background on the Act to understand where it's coming from and the intention behind it. And certainly the government approach to it is that they wanted something which helped reduce the red tape for businesses, because I think one of the criticisms has always been of GDPR and UK GDPR is that it's quite bureaucratic, it's quite difficult for small businesses and charities to comply with. And that's even recognised at an EU level, because they're having a look at GDPR to see whether or not there can be some sort of relaxation for smaller entities. So the government wanted to make it to reduce red tape. They also wanted it to clarify some low risk activities, so that obviously some uses of personal data are quite high risk, some are low risk, and the government wanted it to be clear when low risk uses of personal data were being carried out, what the position was, and try and make it easier for those sort of things to happen. So there is a sort of rationale behind it, in terms of it also was to facilitate technology and developments in technology, and one of the things that I will be talking about is automated decision making and how that helps AI. So they did have one eye on AI. It's probably worth knowing that there is no UK AI Act at the moment. There is an EU one. It is proposed that there will be a government-backed AI Act probably spring next year. But in the meantime, there is some facilitation of AI through the changes here. One thing that does need to be borne in mind is that whilst there are quite broad changes to some of GDPR in the new Act, the government is very keen to keep EU adequacy, which is the free flow of data between the EU and the UK. So what's happening when? If we can move to the next slide, you'll see that I've put on a broad timeline in terms of what is happening. So as I say, 19th of June was royal assent. There's then piecemeal implementation of the different provisions, and we've got some key dates, with others are a little bit up in the air, but we've got a broad idea when they're going to happen. So the first thing to note is that the changes relating to DSARs, and Josh will have a look at those later, were brought in on the 19th of June, so they're already in force. We've had some codes of conduct issued by the ICO in terms of drafts though. So there is a consultation in relation to complaints, and there's also some draft legitimate interest guidance that's out there as well. So there is guidance coming out. Anybody that lived through the changes of GDPR will know that slow guidance makes life very difficult, and I think the ICO is very keen to make sure that prompt guidance comes out for supporting the new Act. It's intended that as we head into winter, further guidance will be issued, so around international data transfers, some further information about complaints, purpose limitation in terms of how data can be used, etc. 19th of December is a bit of a big red letter day for this Act, on the basis that most of the data protection provisions should be in by the 6-month mark. And there's a date on there that's not directly related to the Data Use and Access Act, and that is the 27th of December. That's the point at which the EU will definitely make a decision about adequacy. Things are looking good, but it's worth just bearing that in mind as being a date. And then the 19th of June, which is a year on, all provisions of the Act should be in force, and it's intended that all guidance will be issued by that date. So that just gives you a broad timeline as to what's happening when. So what does it say? What are the key changes? So moving on to the key provisions, and the next slide, you'll see that the first one we're talking about relates to cookies. So as I'm sure you know, you'll have seen the cookie banners, you'll have seen the cookie policies and preference centers and things like that. Cookies have developed. Cookies are a lot more sophisticated these days, and there are quite detailed rules around the need for consent. As it currently stands, prior to the Data Use and Access Act, only cookies which were strictly necessary could be dropped without consent. That was considered by the government to be quite restrictive, and so the Data Use and Access Act position is that there will be some cookies that can be dropped without consent to make life easier. So you'll see on the slide that we're talking about things like cookies which collect statistical data to improve service or the look of the website, enhancing the appearance of the website, user preferences, things like that. I think that comes back to the point I was making about low risk uses of personal data, in that they're not particularly intrusive, and so the government thought it proportionate for those sort of cookies to be able to be dropped without specific consent. There are some, as you can imagine, there are some rules around them though, if you're going to rely on it, in that any use has to be transparent. I mean, that's nothing new, to be fair, on the basis use of cookies needs to be clear in your cookie policy that's on the website, or your privacy notice, or preferably the two cross-reference. So transparency is going to be important. An ability to object to the dropping of the cookies, and one that is a bit of a theme of the Data Use and Access Act in terms of purpose limitation. Purpose limitation is looked at in a number of different areas, and certainly for cookies, they're very clear that if you're going to rely on this new latitude to drop cookies without consent, you need to make sure that you stick to the purpose for which you're allowed to drop them. So you can't drop them without consent for maybe collecting statistical data and then start using them for marketing. So that's one of the key changes. One of the really big ones is in the next slide, which relates to automated decision making. So as I flagged in the introduction, this is one of the changes to facilitate better use of AI. The government was very keen that data protection wasn't seen to stand in the way of technology. It has to be proportionate, it has to be controlled, but certainly they're very keen to facilitate the use of AI so that the UK is a leader from an AI point of view rather than following. I thought it'd be useful to have a quick look at where we are at the moment, where we've started, and where we end up from a data use and access point of view. So what is automated decision making? So automated decision making is where there is a decision that is made purely by computer without any meaningful, really, human involvement. If that sort of decision is being made and there is a significant impact as a result of that, so for example, it makes a decision as to whether or not somebody's recruited, so it's used for filtering CVs and is purely a computer-based decision as to who's interviewed or who gets a job or those sort of things. If there is a significant decision, then Article 22 prohibits automated decision making unless 3 grounds are met. So you can use automated decision making if it's necessary to enter into a contract, and the key word there is obviously necessary. It can't just be convenient, it's got to be reasonably necessary. The use is authorised by law, or the use of the automated decision making is based on explicit consent. That's quite tricky, particularly in the areas where quite often it's used, which is in the potential employee or employee scenario, because consent is not something that you should be using with employees because of the imbalance in the relationship between employer and employee. So as you'll see, from an automated decision making point of view, if a decision is made purely by a computer and it's got significant consequences, it's very difficult to actually do that. And as I say, that comes from GDPR and is in UK GDPR. So moving on to the next slide, you'll see what the position is in relation to what's proposed, well, what is happening under the Data Use and Access Act. So the concepts are very similar under the Data Use and Access Act. Again, no meaningful human involvement, essentially a computer-based decision. It flips things though. So if you're talking about ordinary personal data, so not special category data. So special category data, as you may well know, covers things like health data, ethnicity, political opinion, trade union membership, things like that. So provided it's ordinary personal data and not special category data, then essentially, provided some safeguards are met, then you can carry out automated decision making. If it is special category data that you're talking about, then similar controls to those that applied previously will apply to special category data. So if you're going to make an automated decision based upon, say, health information or something of that nature, then it is more strictly controlled. And so you can only do it where it's necessary for a contract, it's authorised by law, or it's based on explicit consent. Again, you'll recognise that that's the same as what we were just talking about. So it is relaxed in terms of what the safeguards are, in terms of individuals have to be told about the automated decision making and have information about it. I think that's really important because obviously transparency from a use of data point of view is a sort of core thread that runs through any data protection legislation. I think one of the things that will be interesting is the level of detail that needs to be provided in relation to the automated decision making, and that could prove to be quite challenging. The individual has to be able to make representations about the decision making. They need to be able to request human intervention and contest the decisions that are made. And I think the human intervention point is quite important because obviously some people will regard there being nuance in the decision and they want a human to sort of take a step back and think about it. The ICO is required, as you'll see on the slide, to develop automated decision making and AI codes of practice. So we'll definitely wait to see what they say, because I think they're going to be really interesting in terms of, as with a lot of data protection issues, the devil will be in the detail in relation to the guidance, but certainly I think one of the questions, the pre-posed questions that we had is what does this going to do from an AI point of view? This is very firmly focused on AI decisions, so I think it is a key change in the Act that we're talking about. Moving on, something else that I think is useful for businesses are recognised legitimate interests. So as I'm sure you all know, if you are going to use personal data, there has to be a lawful basis to use it. And there are a list of what the lawful bases are. There's a list in Article 6 in relation to ordinary personal data. And then there's an additional set of conditions in Article 9 where it's special category data. Generally, if you're going to use a legitimate interest is one of the Article 6 lawful bases, and it's quite widely used because it's quite flexible. Certainly from a business point of view, it can't be used from a public sector point of view, but from a business point of view is very, very widely used in our experience because it has the flexibility. The only thing that's slightly problematic about it is that there is an element you have to be able to establish what your lawful basis is, and that you're using the data for that purpose, and you have to carry out a balancing test in terms of, is it proportionate in terms of your use of personal data. So sometimes it's quite difficult to carry out the balancing test in terms of, is your use of personal data proportionate to the rights of the individuals? What's going to happen under the Data Use and Access Act is that there will be some recognised legitimate interests, which are definitely okay, and then there are going to be some uses of personal data which are likely to be okay. Apologies. If it's a legitimate interest which is recognised, sorry. Then it can be carried out without the balancing test. So sorry about this frog in my throat. You'll see on the slide that there is a list of what the recognised legitimate interests are. So things like disclosure to public bodies, safeguarding vulnerable individuals, etc. If that is a use of the personal data, then you don't need to carry out the balancing test. In addition to that, there are uses that are mentioned in the Act which are likely to be okay. And I think certainly they're going to be pretty useful from a business point of view in terms of intergroup data sharing, information security, and direct marketing. Direct marketing one, I think, will be particularly interesting in terms of what the guidance is going to say around that. But I do think this is going to be really useful for businesses in terms of, it is one of the areas where we're regularly asked in terms of, will this fall within legitimate interest? Will it not fall within legitimate interest? So I do think this will be really helpful. Now, fortunately, I'm going to hand over to Josh for the next slide, and then I can go cough in peace. So apologies for the disruption.
Thank you very much, Joanne, and good afternoon, everybody. So DSARs, and in short, as Joanne has hinted, they're not going anywhere. The position, as it was before, not a great deal has changed in real terms, and that's because the DUA Act has taken steps to incorporate existing ICO guidance on how to handle them, and this is now forming part of the legislation itself. So on the slide, we're just going to take a quick look at how that ICO guidance has been incorporated, and the notion of stopping the clock when it comes to seeking clarification from an individual. It is confirmed now in the legislation that that will pause the timescales. So when you have a request for, I want all my personal data, and you go back and asking, can you please provide clarification on this? The gap between waiting for the response to that you asking for clarification and waiting for the response, the timescales are paused. Now that was already the case before, but it is now in the legislation itself. So it just provides a bit of additional clarity there. The next thing is that it's confirmed that a DSAR is a right to access personal data only, and that for controllers, they are only required to carry out what's known as the reasonable and proportionate search for that personal data. Again, something that was the case before, but it is now clearer set out in the legislation itself. And of course, once you've gone through that search, there may well be exemptions that apply to that personal data. And when it comes to applying those, and also more importantly, explaining it to the individual which exemptions have been applied and why they've been applied, that is made absolutely clear now that you need to provide a rationale for the application to the individual themselves. And of course, if they're not happy with that response, you should be providing them with enough information on how they can make a complaint in response to that DSAR. And again, that's something that we're going to cover later on. Now, moving on to the next slide. We're just going to delve a little bit deeper into the ICO's position when it comes to clarification, because whilst DUA has incorporated the ICO's guidance, they have taken some further steps from the introduction of the DUA Act. So as I say, much of it does remain the same up until we get to the point where no response is received. So DUA has confirmed now that you should wait what's called a reasonable time. And the ICO has said that that's typically 1 month. But if you don't receive a response to your request for clarification by that time, you can consider that aspect of the request closed. And it is just worth noting there, just to be absolutely clear, that the ICO does not would have the expectation that for anything that does not require clarification, that timescales for one are not paused, but equally you can't consider the rest of that request to be closed. So if there's anything that does not require clarification and that you can reasonably provide, that should be provided within that initial calendar month. So it's only considered closed in respect of what you're asking clarification on. And now as we move on to the next slide, just going to take a step back from DUA itself. And it's just really to highlight that there has been some activity from the ICO recently in this area. But again, I will just preface that this is very much an extreme case, and that in the ordinary course of business, the ICO, as long as they're seeing progress, they're not going to take this sort of action. But it is just worth exploring. So there's recently been a case of a care home director who refused to comply with a DSAR, and in doing so, ended up concealing and erasing personal data which came within the scope of that DSAR itself. Now, the action that was taken, this has led to that care home director facing criminal prosecution, as well as a fine and being liable for those costs. So it's just one of those, as I say, rare cases where it's just to remind those individuals that it is a legal obligation to comply with a DSAR. And that for any deliberate action which works to restrict someone's right of access to their personal data, then it can result in criminal enforcement. It's not just a civil penalty itself. But as I say, this is very much one of those cases that sort of appears and is not indicative of what the ICO will do on a regular basis itself. But I'm now going to hand back to Joanne, who will pick up now from a exemptions point of view.
Thanks, Josh. So this is having a look at something which is only really of interest, I think, to charities. Direct marketing is always something that we get asked a lot about by both businesses and also charities. And there are rules around it, and the ICO is very active in taking action in relation to direct marketing breaches. So I think it's worth contrasting at the outset what businesses can do and what charities can do, because charities we're in a much worse position than businesses in relation to direct marketing. So we're looking at electronic communications by way of marketing. So generally that would be email, SMS. When we get to talk about the change that's been put in place for charities, we're only talking about email. But if we look at it generally, electronic marketing, email, SMS. Where you're dealing with direct marketing via electronic means, not only have you got UK GDPR to deal with, but you've got the Privacy and Electronic Communications regulations, which are generally known as PECA, and they overlay onto that and add additional requirements. I think it's also useful to know what we mean by direct marketing. I think it's quite easy to understand in the commercial context, but I think from a charity's point of view, it's not so clear. From a charity's point of view, it involves the promotion of the aims of the charity. So fundraising and the promotion of charitable aims would be direct marketing and would therefore fall within UK GDPR and would also fall under the Privacy and Electronic Communications regulations. The general position in relation to electronic direct marketing is that UK GDPR level consent is required. Commercial businesses, however, could take advantage of an easier way to be able to market because it's quite difficult to get UK GDPR level consent. And commercial businesses could use what is called the soft opt-in. And the soft opt-in is used like where you've bought something from a business and then they continue to market to you. So if you have bought something from a business or you've been in negotiations with that business essentially they can then contact you in relation to the same or similar products, provided it is the business, not a group company, and you've been given an opt-out at the point at which your personal data is collected, and there's essentially an unsubscribe in relation to other communications. So it's more of an opt-out than an opt-in. Obviously, getting GDPR level consent is opt-in. A soft opt-in is more of an opt-out. So it will happen on a commercial basis, generally, unless you've opted out. So that makes life a lot easier. But charities were unable to use the soft opt-in, so they were having to obtain UK GDPR level consent to be able to fundraise, promote their aims, etc., which made life very difficult. And I think there was generally a view that it wasn't really very fair on the basis there wasn't a level playing field. So moving on to the next slide, you'll see that there is a change that is brought in by the Data Use and Access Act in relation to charities. So in a nutshell, charities can use the equivalent to the soft opt-in in relation to sending direct marketing, i.e. fundraising, promotion of their aims, but it only applies to email, doesn't apply to SMS. The rules are the same, as I say, so essentially it has to be the same charity. It can't be from any form of associated organisation. It's got to be for the purposes of essentially promoting their aims. You've got to have had contact with the charity, so there's got to be an expression of interest. You've got to have engaged with the charity for them to be able to use it, and there has to be the opt-out and unsubscribe in the same way that there is for commercial use of the soft opt-in. But I think it is a very positive thing for charities because it does make life a lot easier. As I said, it's quite hard, and statistically the number of people that will give you opt-in GDPR level consent to marketing is much lower than you're going to get if you use the soft opt-in. So I think this will certainly significantly help charities with their fundraising, and I think is something that will prove to be very useful for charities with the reform under the Act. So now we're moving on to complaints, and I'm going to hand back to Josh.
Thank you, Joanne. And yes, complaints. It was something that I hinted at very briefly just a moment ago. And the original position before DSAR Act was that there was no statutory obligation on a controller to have a formal complaints procedure in place. And we have now seen a shift. So this has all been born out of the ICO seeing a trend for an increasing number of complaints that they were having to field. And for this year, they estimated that there would be between 45 to 55,000 complaints in the year, which is 15,000 more roughly than there were 2 years ago. So these complaints, they have to consider every single one, although they will decide whether they're going to take any further action, of course. But clearly, that trend is going to be unsustainable for the ICO, particularly in light of the level of resource that they have internally. So as a result, the DSAR Act is passing that obligation on to organisations, and they must now have a formal complaints procedure in place, at least a process for individuals to follow. And that once a complaint is received into the business or wherever other controller as it might be, this complaint must be acknowledged within 30 days and then take appropriate steps without undue delay to deal with that complaint itself. So whether that's confirming the nature of the complaint and generally keeping the individual informed, that's now a new obligation on controllers. Of course, if they're still unhappy, then the ICO do still accept complaints from individuals. However, they would have the expectation that they're going to go through the process with the controller first. And equally, once a complaint is received into the ICO, they're due to be setting a number of thresholds at which whether they are going to consider that's going to trigger a deeper review. So at the moment, this is subject to change. It's undergoing a consultation, but things that they might consider as thresholds might be whether this is the 6th complaint in the last 2 months, or whether they're seeing a 50% increase month on month versus before, effectively. So the ICO are still going to be taking complaints into consideration, but the first step, particularly for individuals to follow, is going to be one to go through the controller, and the controller themselves must have a process in place by which an individual can make that complaint. And I'm going to hand back over to Joanne, because I believe you've already mentioned before the purpose limitation, and there's some more to be said on that.
Thanks, Josh. So as Josh says, one of the core principles of UK GDPR is that you've got to be transparent about how you're using personal data, and you've got to use it for that purpose, and you can't have purpose creep. So you can't use it for any other purpose unless that is regarded as compatible. So any incompatible purpose you can't use it for. Obviously, that begs the question in terms of where's the line drawn, in terms of what's compatible, what's not compatible, and it does lead to quite a lot of confusion. So the idea behind the changes under the Data Use and Access Act is to be clearer about what is compatible, what's incompatible. So the general principle stays the same. But there is some guidance in terms of there is further information under the Data Use and Access Act as to what can be regarded as being a compatible different purpose, and how you can work out whether it is compatible. So that would take into consideration, as you'll see on the slide, things like is there a link between the new purpose and the original purpose? Is it sufficiently close for it to be regarded as compatible? Essentially the data was, what was the context the data was collected in? Is it sort of to be expected? Is it close, this new use of the personal data? Whether it's special category data. As I said earlier, there are particular types of personal data, such as health data, which are regarded as much more sensitive than ordinary personal data and essentially have to be handled with kid gloves. Less likely you're going to be able to argue that it's a compatible purpose if it relates to special category data. Essentially, things like what are the consequences? Is it going to be something that the data subjects are going to expect, or does it have little consequence for them? All sorts of things like that are going to be the things that would mean that it's more likely to be regarded as being compatible, and therefore the use of the personal data for a particular purpose when you collected it can be used for these additional things. One thing that is particularly helpful is that there's an idea also of something called compatible purposes, recognised compatible purposes. And what that is essentially is a list of things that will be regarded as being okay in terms of an extension of the use of the personal data. They will be regarded as something that is compatible and therefore okay. You'll see on the slide I've put a list of them. They're not things that I think are particularly contentious. They're the sorts of things that you would expect to be okay in terms of using personal data for if you collected it for a different purpose. So it can be used, for example, for detecting crime, prosecuting people, safeguarding vulnerable individuals from both mental or physical harm, national security, defence, emergency response, which could be environmental disasters or national security incidents, things like that, and taxation and legal compliance. As I say, those shouldn't be particularly contentious because they are things that most people would assume you can use personal data for anyway. But I do think it's useful that there is more clarity around where the extended use of personal data is compatible or incompatible. So I think that'll be useful for people to make that assessment going forward. So now we're going to move on to the concept of there being additional categories of special category data, so the types of data I've been talking to and about, and I'm going to pass back to Josh.
Thank you, Joanne. And special category data has been mentioned quite a lot already, and we already have a list of what special category data might be. That's already been set out in UK GDPR. This hasn't changed. It's as listed on the slide, and we've also got criminal offence and criminal convictions data as well. Where things are potentially changing, and this is with the idea of having greater flexibility under the DSAR Act, is that although the list hasn't changed, it's not fixed. So the Secretary of State has now been granted the powers to add to the list. And I stress add, they can't remove any existing special categories of personal data. But to meet emerging tech, any developments that might arise over time where things might shift from potentially being initially seen as ordinary personal data to flipping into potentially being more sensitive and requiring that additional title of being special category personal data, the Secretary of State can add to the list, at which point they will be afforded greater protections for certain categories. And it's one just to keep an eye on. It's one that may well come out at some point. Again, the Secretary of State may decide that some personal data is warranted to be classed as special category data. So that's a change versus UK GDPR. But as I say, for the moment, things remain the same. And I will flip back to Joanne to pick up on the next point.
Thanks, Josh. Be a bit less ping-ponging between the two of us now. So the next point is in relation to children's data. The ICO generally regards children's data as being something that needs to be handled very carefully. There is an overall view that obviously because children aren't necessarily that sophisticated and don't understand how their personal data is being used, that children's data has to be handled very carefully. The Data Use and Access Act builds upon that in relation to essentially information society services, which are online services and are things like streaming services, online stores, apps, things like that, social media. And in the context of one of these services, then the new Act requires that children's personal data is definitely handled with kid gloves, and that there has to be consideration of how children can be protected when they're using the services. There has to be a recognition, and it has to be factored into how personal data is collected and used, that children are less aware of risks relating to the use of their personal data, don't always understand it, and a consideration of the different ages of the children. So what sort of age of children does the app or streaming service, for example, apply to? You need to think about who the customers are, who the potential consumers are, and therefore tailor it accordingly. So I think it is useful in that it makes it clear that it's in a particular context. There has to be particular consideration of the vulnerability of children, but I think anyone handling children's personal data needs to be aware that the ICO generally regards children's personal data as being something that needs to be handled very carefully. We're waiting guidance for further information on this. So moving on to the next slide, which is around scientific research data. You remember earlier I was talking about the fact that you collect data for a specific purpose, and that essentially you can't use it for incompatible purposes. Scientific research data, it does get a little bit of special treatment in that regard, in that there is some latitude around that in terms of it can be used for broader purposes. The Data Use and Access Act does put a bit more information around that, and it is quite useful to understand that if you're carrying out scientific research. So essentially, you'll see on the slide that where personal data has been collected for scientific research, it can be used for further research, which is broader than that for which it was originally collected. So not going outside the research context, but essentially staying within it, but for other types of research which are sufficiently close. That principle is strengthened by the Data Use and Access Act. It also makes a couple of things clearer. So one of the things is that scientific research includes commercial research, because there's been a discussion following GDPR and UK GDPR in terms of where there is some latitude in relation to scientific research. Is that just publicly funded research, or if it's commercial research in a commercial business, does that also get the benefit of the latitude? And it's now been made clear that commercial research is covered. Also, something that is useful and has been clarified is that where consent has been taken to use personal data for scientific research, that can be essentially you can take a broad consent. So for those of you who will be familiar with UK GDPR level consent, you'll know that it has to be very granular. There is some latitude, as I say, in relation to scientific research, and it's now been clarified that essentially you can take a broader consent to use the personal data in other research, subject obviously to certain safeguards, and a lot of these things that are in the Data Use and Access Act, which are diluting, well, not exactly diluting, but are clarifying and giving a little bit more space to breathe in relation to the use of personal data, are subject to safeguards. So it's useful to know that certainly you can take a broader consent, not just for the specific research that you're talking about. So that should be useful. So I'm just going to hand over to Josh for a roundup of the changes before we have a look at what the practical impact of this all is.
Thank you, Joanne. Yes, so yes, just to wrap up the the final change discussed today under DUA before we go on to the practical guidance. So GDPR levels for PECA breaches. As a result, the ICO has gained some enhanced enforcement powers. The previous position was that they could levy fines up to £500,000 for breaches under PECA. That is now changed, and the fines are now being brought up to UK GDPR levels. They've effectively supercharged the powers in this regard. So it can be, well, it's from 500,000, it's now up to £17.5 million, or 4% of global annual turnover. It's just one thing that we thought we'd mention, as it is certainly important for organisations to be mindful of, particularly when it comes to making decisions about cookies and direct marketing, as we've discussed today. So the upper levels, we might not necessarily see them meeting those levels when it comes to cookies, and they might maybe reserve those more for cases of direct marketing. However, it is certainly something, as we say, to be mindful of. So I'll hand back now for the final time for Joanne to cover off the practical guidance points from today's session.
So now we're going to have a look at what you should be doing and when you should be doing it. So as you can see on the slide, we've put a broad timeline on it, not written in stone, because for anybody that has waited for ICO guidance in the past, you'll know that sometimes these dates aren't hit, but they are broad idea of what you should be doing when, assuming that the guidance is available. So as I said to you earlier, the provisions relating to DSARs are already in force. So you should be looking at your DSAR practices now. You can take advantage of the fact that all searches now need only be reasonable and proportionate. So it's probably worth having a look at your DSAR practices and any training. I think it's also useful to, as I say, have a look at your ability to clarify DSAR requests as well. Factor that into your documentation and your training. A lot of these changes will depend upon you knowing what personal data you've got and how you're using it. So I think it's a good idea to map your personal data so you know what you've got, and in particular what you've got that's special category data. Also in terms of where you use legitimate interest, because if essentially legitimate interests are potentially going to be expanded, it's useful to know where you're currently using it. Do any of those uses fall within a recognised legitimate interest, so you don't need to worry about legitimate interest assessments? Does it fall within the scope of those which are likely to be permitted legitimate interest, which will make your life easier? So understanding what you've got and the lawful basis for how you're using it is always very useful. In terms of moving on into winter and spring, as I say, monitor ICO guidance. I think look what's coming out when it's coming out. You'll get an early look at it if you watch the ICO website, because there are generally consultations or drafts that are coming out. And while sometimes they do change between when they're originally released and final version, they don't change a huge amount generally. So I think getting an early look at it is quite useful. Have a look at your cookies, I think would be useful as well. Know what cookies you've got. Identify any of those that potentially could fall within the ability to use cookies without consent. Have a look at your cookie policies, have a look at your cookie banners in terms of, do you need to update those in terms of clarity, providing information about things. Complaints handling, as Josh was saying, you will be required to have a complaints procedure. So have a look at where what you've currently got from a complaints point of view. Do you need to add anything in relation to the use of personal data? Automated decision making. I think getting an understanding of how you might want to use automated decision making using personal data early would be useful, so that when that comes in, you're all teed up and ready to use it. Moving on to the next slide. Longer term actions, I think, is to keep on top of any ISO guidance that's not out by the turn of the year. I think it's also useful for when most of it is out to take a step back and look at all of your data protection internal documentation, look at policies, look at procedures. Are they reflecting everything that has changed? Are they reflecting all of the new guidance? Staff training. Essentially, you should think about any training that you're going to need to do in terms of wrap-up training as a result of any of the changes. Look at your privacy notices, look at your record of processing activities, make sure all of that is up to date and completely reflects what you've got. And as I say, I think cookies should definitely be high on the list of things that you should be doing. So I gave you a brief timeline at the beginning, and then this is a quick sweep up timeline. So I think it's worth planning, I think is what I'm saying, in terms of have a look at what you've got, what's coming down the line, what the ICO is saying, and what documents you need to update. So that's the end of the presentation. If anybody has got any questions, then please do submit them in the Q&A. We had one pre-submitted, which was around what's this going to be doing from an AI point of view. As you'll have seen, there are some provisions in there, particularly around automated decision making, that help from an AI point of view. It isn't specifically focused on AI in terms of the changes in the Data Use and Access Act, but again, watch this space in terms of the government-backed AI bill, which we are expecting sort of in the spring. Any other questions? I don't think we currently have anything. Obviously, if you think of something and you want to drop me a line, then please feel free to do so. But other than that, then we'll call it a day. Thank you very much for coming along and attending. If you can fill in the feedback form, that'd be great. And just to confirm what I said at the outset, you will get a copy of the slides and also the recording. Thank you very much.